So now we'll be moving on to our first session of the day, a roundtable discussion on international law, teaching and researching in ASEAN countries. And for this panel session, we have a very exciting lineup of speakers moderated by Professor Anthony 𝐏𝐫𝐴𝐵𝐬. As many of you will know, Professor Anthony 𝐏𝐫𝐴𝐵𝐬 qualified as a barrister and solicitor of the Supreme Court of Victoria, and he practiced law in Melbourne before commencing his graduate studies at Harvard Law School. He was appointed a senior fellow in the Harvard Law School graduate program and then went on to teach law at the University of Utah, where he was the Samuel D. Thurman Professor of Law. For our panelists today, we have Dr. 𝐏𝐫𝐴𝐵𝐬, Associate Professor Dr. Chan Viet Tung, Associate Professor Salawati Mat Basir from Malaysia, Associate Professor Ari Afriansyah from Indonesia, Ms. Dani Chanraksmeh-Chukroth from Cambodia, and Dr. 𝐿𝐿𝐿 𝐿𝐿𝐿 from Thailand. And I will tell you a little bit about all our wonderful speakers for today. Professor Zung is the Dean of the International Law Faculty, and he lectures on international investment law, globalization and law, World Trade Organization law, ASEAN law, international dispute settlement. He holds a PhD of law from NUS, and he read international studies in the People's Friendship University of Russia and International Trade Policy Program at Harvard Kennedy School. Associate Professor Dr. Salawati is the Public International Law lecturer and legal advisor at the National University of Malaysia. Prior to joining the National University of Malaysia, she also held several professional positions, including practicing advocate and solicitor, legal officer at multinational companies, and a post-conflict officer with the UN Conference on Trade and Development. She holds her LLB, her LLM, and her PhD from the National University of Malaysia. Ms. Chukroth is an attorney at law and an assistant to the Ministry of Foreign Affairs and International Cooperation in Cambodia. Before joining the ministry, Chukroth has also served as a deputy director for the English language-based Bachelor of Law program at the Royal University of Law and Economics. She's also a member of the Executive Council of the Asian Society of International Law and a member of the Executive Committee of Salah Traju Association, where she provides lectures on various international law topics. Professor Ari is an associate professor at the Faculty of Law, Universitas Indonesia. He also is the chairman of the Center for Sustainable Ocean Policy Faculty and the editor-in-chief of the Indonesia Yearbook of International Law, as well as the editor of the ASEAN Journal of Community Engagement. He's the president of the Indonesian Society of Indonesian Law Lecturers. Dr. 𝐿𝐿𝐿 is an assistant professor at the Faculty of Law, Chiang Mai University. She was the recipient of a scholarship from the Royal Thai government to study her bachelor, master, and doctorate degrees in law in France. Dr. 𝐏𝐫𝐴𝐵𝐬 is currently lecturer of the Faculty of Economic Law and at the University of Economics and Law, National University of Ho Chi Minh City. He's currently teaching and consulting in the fields of international trade law and international investment law. So we have a very exciting lineup for today, and without further ado, I'll hand it over to Professor 𝐏𝐵𝐴𝐵𝐬 to give his opening remarks.
Well, thanks so much, Jing, and good morning, everybody. Thank you for joining us on this very special occasion. In terms of introducing the panel, Jing has already given us an idea of their backgrounds and their experience, and we all look forward to hearing their remarks. Let me just thank a few people to begin this whole program. So many thanks to Vice Rector Lee Vu Nam for those very kind words, and to Professor Zung for his introduction. I particularly want to thank Professor Zung and Dr. Phuc for the wonderful work, their dedication in collaborating with each other and collaborating with us to make this event possible. And it was also the idea of Dr. Zung and Dr. 𝐏𝐫𝐚𝐧 to have this special panel on ASEAN, which I think is very welcome and very important, because we need to develop an understanding of the situation among ASEAN countries and learn from each other and from our experience. Let me just say a few words about TRILA before we begin this panel. So TRILA, Teaching, Researching International Law in Asia, is basically designed to develop and understand the situation of the challenges facing teachers of international law in Asia. As Dr. Zung mentioned in his opening remarks, Asia has been regarded more as a rule taker rather than as a rule maker. So the question then is, how can we develop and articulate the Asian voice in a world of international law amidst all these many changes? And we feel that in order to do that, we really need to begin at the beginning, which is with the teaching of international law, because it is your teaching and your research that is going to inspire all the students, all the law students, and also play a very important role in your ministries and various other associations that are concerned about international law in Asia. The other thing I want to say is that international law now, I would claim, affects every aspect of our lives. And the pandemic is just one example of the way in which we need international cooperation to deal with this issue. No country can exist in isolation. And so in the context of all the developments taking place, we need trained international lawyers and international law scholars to understand all the developments taking place. So it is for these reasons that TRILA was established. And I'm very glad to say that today we have on this panel many people who have already been connected with TRILA. And so I look forward to hearing their comments. Let me also say that I'm especially pleased that we finally are connecting with our colleagues in Vietnam. Vietnam, of course, has a very proud history and has fought over many centuries to assert and protect its independence in very difficult international circumstances. So Vietnam has a very distinguished past history, and it is also a country which has a very promising future. Dr. Zung mentioned the many different treaties and arrangements that Vietnam has entered into as a part of its effort to expand its economic activity and progress. And also, let me say just more anecdotally, one thing that struck me was the fact that in the time of the pandemic, Vietnam was playing an extraordinary role in actually producing protective equipment and donating protective equipment, I think, to many countries in those circumstances as well. So those are the opening remarks. Let me just say a little bit about the format of the panel. I've asked, the speakers have been kind enough to share their experiences. They'll be speaking for roughly 12 minutes each. And at 10 minutes, I will be indicating to them that 10 minutes have passed and they have 2 minutes to conclude. We have a rich range of presentations. And so it'll be good if we can get through those presentations and leave some time for questions. So with all that, let me invite Dr. 𝐏𝐫𝐚𝐧 to open with his remarks. Dr. 𝐏𝐫𝐚𝐧 has been long connected with TRILA. He attended the first TRILA conference in Singapore in 2018. So it's wonderful to see you back again, Dr. 𝐏𝐶, now speaking from Vietnam to all of us. So I hand it over to you now.
All right, so thank you very much, Tony. So anyone can hear me clearly? Okay, so it's my pleasure, very happy to take part to the organizing committee of TRILA Vietnam this time. So according to the schedule, so I am Professor 𝐁𝐚𝐬𝐲 will take part in this roundtable discussion because both I and Professor 𝐁𝐚𝐬𝐲 from Vietnam. So I think we will share the role together in order to share some information about teaching international law in Vietnam. So first with the challenges faced by the lecturer during the time of pandemic. So as you may know that Vietnam and like other countries, so since the end of 2019, we faced the pandemic So in Vietnam, so we face, until now we can say that we have 3 waves of COVID-19 in Vietnam. So the first one right after the discovery of COVID-19 in Wuhan, China. And then the second wave would be in Da Nang last summer, I remember. And recently we have a third wave in the northern province of Vietnam, just before the Tet holiday, the Lunar New Year. But luckily, so all of those 3 ways, the government of Vietnam handled the issues very well with strict measures and with quarantines, location, place, right, and control strictly travel in and out of the country. So far at the moment, so everything back to normal now. However, the university in Vietnam as well and the other industries, so we somehow affected by the pandemic. So so the first thing we can recognize about teaching online. So so during the wave of pandemic, so most of the university in Vietnam, we need to work face-to-face learning, right, to e-learning platform. So one more thing very lucky from Vietnam is that the government and other universities in Vietnam, we already have a kind of investment in e-learning platform in recent years. So when the pandemic came, so university, we switched to e-learning platform quickly. And I remember we have like the whole semester, like we taught in e-learning system. So different from university, they use different system. Like in our University of Economics and Law. So you firstly we use Zoom, and then we switch to Google Meet, right? And then we have BB, Big Blue Button system. So we get also of e-learning platform. And for sure, there's one thing that the universities in Vietnam, and I think all the universities is the same. We need to be familiar with something that teaching and learning and research or international collaboration. Now we need to make it through the online platform. We cannot travel face to face in person with other one another. Most of the so you need to do when we do with international partners might be online. So one very clear example is our TRILA today. So since we need to have to face the issues of international with the online learning and collaboration. So with the teacher, we also need to have a different approach to the learner. So when you switch to online right learning system, so there's one thing that we should pay attention. This is the active learning method. Together with the existing difficulties that we are facing now in Vietnam when we're teaching in international law, particularly, or in teaching and researching law in general. So get into more detail with the lecturer in Vietnam. So what will be the difficulties we are facing when we deliver international law process? So the first one we can say is about the language. So I think it's not just the difficulties in Vietnam. When I talk to other colleagues around Asia or ASEAN, so it's the same difficulties. So because of the barrier of language, right? Most of the books, the material is not written in our own language. It's not written in Vietnam, Cambodian, or Chinese, so it's mostly a system in English or French or German. So it's difficult for the scholars like us to research. However, I think it should be improved quickly because capacity in language capacity of lecturer in ASEAN. So I think they improve very quickly. Okay, so another thing is about the financial capacity of the university in Vietnam. So as you know that since the material, the books is not published in Vietnam, so we need to import those books and to compare to the price, the living cost. So it's costly for most of the university in Vietnam. So for example, from the case of our university, so for the textbook of international trade law, when I suggest that you might our university to buy, to supply for the student. So it's like each book, they can only buy like 2 versions, like 2 copies of the books. So the student need to share, the student and lecturer all together, we need to share. The same issues with the international, with the electronic materials. So it's costly, like hand-on, like Sydney's Westlaw. I need to pay a lot of money from a university to buy, and not many universities can afford for those databases. We try as our university, but the resources still very limited for research and teaching. One more thing I would like to stress here is about the connection and collaboration between the scholars in this field in Viet Nam. So as mentioned by Professor 𝐏𝐫𝐚𝐧, so all universities recognize that international law is very important in the teaching curriculum, teaching program of a law school in Vietnam. However, for the collaboration, for the connection, for the academic activities, we not have any official system. It's not organized regularly, annually. So we really need a forum for these activities. And I hope that TRILA will be a good starting point for that. All right, thank you very much, Professor Tony, 𝐴ng𝐬𝐲. So yeah.
Thanks so much, Dr. Phuc, for that very wide-ranging presentation, both in terms of the situation in Vietnam because of the pandemic and some of the very specific challenges that scholars in Vietnam face. And let me just say that these are common challenges. The issues about language, the issues about resources, the issue about collaboration. So in our experience, we found that many countries experience those problems. And so I hope TRILA and our collaboration will contribute in some way to assisting with that whole set of issues. And now if I could ask our colleague, Dr. Zung, who's been worked so tirelessly to make this possible. I'm sure he has had many nights with not much sleep as a result of this program. So thank you again, Dr. Zung, and we look forward to your comments.
Yeah, I would like to continue the presentation of Dr. Phuc, and I just want to give you some overview of the issues in Vietnamese university law schools teaching international law. Actually, as Phuc mentioned, the international law as such is considered as important subject in the Vietnamese curricula, and it's in the Vietnamese legal education. The teaching of public international law is a compulsory subject. Yeah, and yeah, thank you, Emil, for your sharing the screen. Could you please move? Yeah, next, please. Yeah, so yeah, the back, please. Back, please. Yeah. So at the moment, in Vietnam, we have around 80 law schools, and all of them have to teach public international law because it's a compulsory subject. However, in fact, there are only few universities who pay really attention to the research and teaching of international law. That there are like I could list 4 law schools, namely the Hanoi Law University, Ho Chi Minh City Law University, the Vietnam Diplomatic Academy, and the Law Faculty of Hanoi Vietnam National University. For other law school, the teaching of international law is just an introduction to international law. Some big universities, law school, they also teach international law, but the emphasis could be put on the international economic law only. It's like I can just this the same apply to the University of Economics and Law and the foreign trade universities in Ho Chi Minh City. So it means that generally although the society has recognized the importance of international law, the research and teaching of international law in depth is still very limited in Vietnam. Next slide, please. So I would like to emphasize here is that the teaching of the public international law as such is facing increasing challenge when the now government allow the university to design their own programs. So many of university, they just reducing the number of credits for the public international law course in their curriculum to replace by the courses relating to economic law or domestic law, because for them it is more practical. Another issue that the challenge facing the teaching of international law in Vietnam is that now both students and lecturers, they are more interest on the private international law, international trade law, rather than the public international law. And to us, the foundation of international law is still public international law, and then it is very important to understand the rules and the principles of international law before we can start learning or studying other area of law under international law. Okay, next please. Next please, Emil. Yeah. So another issues that we are facing now in teaching the international law is that with the development of international relations and integrations, Vietnam exposing to many new area of law, many area like especially when we enter into the new generation free trade agreements like CPTPP or EU-Vietnam FTA. The Vietnamese government and Vietnam have to commit with many international commitments relating to environment, human rights, health protection, and cyber securities, and they're also relating to expropriation of foreign. So this is all the area that we consider as a non-traditional topic of international law, and we all have to accommodate in the program. So and given the fact that the school is reducing the time, the credits for teaching international law, is very challenging for us to teach the international law. Next, please. Another issues that we need to explore and teach for the student, which is very complex, is relating to the many concepts of the integrations, the regional integration, and the keep of the state sovereignties, and new issues relating to the technologies like the freedom of transfer of data and the national securities, protection of environment, and protection of economic interests of investors. So all those issues, we have to create new subjects for the teachings to elaborate the problem for students, but we are not allowed. We don't have enough time in under curriculum of the legal program, LB program, and this is a big issue. Then next, please. And the last, and I think that important task for us is to how to make the whole society understand about the impact of the international treaties in Vietnam. Generally, when we teach when we teach the international law, we also always say that the states must comply with their international treaty obligations. Why? Because it is of their self-interest. Because it is of their benefit from the reciprocity and compliance, and because of the sanctions for non-compliance. But it is very clearly that with the current development, all this explanation may not be correct, because the implementation of international treaty not just depend on the government. It depends also on various objective factors, and including the understanding of the society about the law. understanding of the policy maker about the role of the obligation of all the states. So so it is, and therefore we propose and that the international law course must be incorporated into the content of the domestic law courses. However, it is very hard because the teachers and the lecturers who teaching the domestic law courses, they don't feel it is important. They many of them just feel that, you know, we just need to teach what is written in the domestic law, because they assume that international obligation of the states have already been incorporated, have been transplanted into the domestic law, but in many fields, many area, it is not. So I think this is also an issues that we are facing, and we are trying to resolve, yeah, in one another way. But that is I think the general pictures about the issues and challenges for the Vietnamese law schools in teaching the international law in at the current stance. Yeah, so this is all of my presentation. I know that time is very limited, so I give you know, I stop here, and maybe we can discuss in later on at the Q&A session. Thank you.
Thanks so much, Dung, for that wonderful presentation, and also for keeping to the time. You have raised so many fascinating and important issues about the curriculum and about the relationship between international and domestic law. But we will keep those issues in mind and discuss them later, because I'm sure further speakers might also have something to say about this. So now, if I may ask Dr. Salawati from Malaysia, who's also been a wonderful supporter of TRILA. Dr. Salawati came to the first TRILA in 2018 and was also very helpful in TRILA Malaysia, our previous TRILA program. So Dr. Salawati, may I hand it over to you? And I'll let you know after 10 minutes have passed. Thanks.
Okay, thank you, Professor Tony Ng. Hello, everyone in Vietnam and around ASEAN country. My name is Salawati Mat Basir from National University of Malaysia. I would like to, because of time is constrained, I don't have a slide, but I want to explain to you the challenges and obstacles that we in Malaysia are facing when we're teaching public international law and others international law subject. First of all, that we are British common law system. So our students in Malaysia is always think that after graduate, they want to become a corporate lawyers or litigation lawyers. And international law is like not actually part of it. And when curriculum in Malaysia by the Ministry of Higher Education put that public international law as a compulsory subject at third year at a law school, then it start to give new dimensions for all of us as an educator, as in international law. First of all, that the question has always come to us as lecturers of educators in international law is how we should teach, and what we should teach, and how to explain to the student that international law is a very special subject. It cannot compare with any subject in a domestic law. You know, I'm not saying that the domestic law is not important, but I want them to know that it's so special, it's have a special place in our syllabus. So we try very best that early at the second year level, before they enter the third year, we have an introductory course to public international law. This is what we do in our university and start following by other universities in Malaysia, because they have to understand what is meant by convention, treaties, you know, they have to understand and distinguish all these things before they can enter. And what is makes special in my university, we have the nuclear science program student that take nuclear law as a part of a compulsory subject to graduate. So can you imagine that is we have to teach a science student with nothing more about international law or very simple basic domestic law. So it's a really challenge because we have to start from scratch, even worse, because they don't know anything. We have to tell, okay, when you talk about the protocol means like this, and we have to give them all in the environment of nuclear science. All right, and then what is other major challenges for us in Malaysia? Because people, our economics still challenged at this time during the pandemic and still struggle. And we can still see that the domestic law play more better than international law. However, after the ASEAN integration, the government start to ask the Attorney General chambers to enhance more, our awareness. So what is our responsibility is the teacher at the law school to tell the student that from the first year, when they enter the first day in a law school, we start to talk about how the integration and international law play a very important part. We did last week when the first student come, and I can see different. Now the students start to think that I can practice not about the local law, but also around ASEAN and around the world, as long as I can understand the public international law very well and how is it played. I can relate the two previous speakers before that very important for students to understand the investment law, the trade law, and how especially the taxations, because this is the field that people are too scared in Malaysia to take care of. For them, like, what is that? Tax, money, why? We don't want it. But then now we start to be very friendly to them. This is the, I can say, the field that the student can explore, and even many of our international law lecturers also start to explore. This is something that a must at this moment. And then online teaching is also another challenge to us, because previously we have face-to-face with students. When we have online teaching, some students have the very bad connection to us. Some students, they don't want to show their face, and you have to call them many times. You don't know whether they understand or not. And this is the dialogue between lecturer and student need to be more enhanced, and the lecturer have to work double to ensure the student understand what we teach. And then what about the problem-based cases that we give to them? And normally what I'm doing is I take the latest case happen around the world. I put it, because otherwise they don't read, or they just like still to think that this is public international law is special, but I think maybe it's okay for me not to understand at the beginning. When I come to the exam, we will read. No, that's supposed not to be that way. And also another challenges is the resources, because normally students have the hard book, all the journals and all that in the library. So when the pandemic happened, we closed the university and they not come and cannot get it. So I have to ask my university to have an allocation. Despite the allocation being cut by the government, we still ask for the government to allocate for the e-books and also e-journals. We don't have a problem in e-journals because we get it for past 10 years, but e-books, because the international law book is very expensive. So we need to have e-books, and we have to educate everyone to get the e-book because they are scattered around Malaysia. So this is another challenge, because universities start to say that if we give it to you, what about the other subject? So we have to fight. And so far, we very successful by fighting this thing, because I come up with the idea that we have to do this. Because we cannot just give a reason pandemic. I think the pandemic is a pandemic, but it's not going to stop us to ensure that our public international lessons should be enhanced from time to time. Secondly, we put everything, the latest issues in our syllabus. Every semester, we in a law school will revise back our syllabus, what we should do and all that. We have to do this because we don't want our students to have a lack of knowledge or lack of something. Because nowadays, the trend in international economic law, international development law, so they must be put inside that. And also dispute settlement, because previously people are more talking about on the, for example, outer space law and all that. Now, I'm not saying outer space law is not important to Malaysia, but we put, because of the time constraint, we have 2 semesters, have to cover it. So we only have to sit down, all of us, and put what is important for our students, because we are preparing them to serve after this, especially for our AGC or our international firm. So this is how we do, and we have to play very active role. Otherwise, the other lecturers who are not come from background international law, they don't know. They are still thinking that it's just a part of the syllabus for the 3rd year, but for us, it's not. It's a survival for the country, for our new generation, especially during this integration time. And also, I think what we do is we connect our university, our institution with the people in the public international law. For example, we have a connection with people IMF, WTO, ASEAN Development Bank, every OIC, UN, because we want them to come and give talk or through webinar to our student. Students don't want much to listen to the lecturer. Beside my own experience at the UN, for them, I see you every day. You know, I know you are in the law school. I want to hear someone else. So we bring many Malaysians who are abroad or our ASEAN counterparts that abroad through webinar, talk to the student and give them motivation why public international is very important for them. So far, I think we are very successful by doing that. I think another challenges on online class is the students' understanding. So what we try to do is we try to give a very simple reading to them, and then we keep asking them, and then we give them work or assignment which is can connect them with their friends or the latest issue that they can get from news, from newspaper, from online and all that. Because we can't ask too much during this pandemic, but I still want them to understand what we teach. So this is among the problem. But another serious problem that I face for so long as a lecturer in international law is when you have a colleague who do not have background of international law, but try to tell that I can supervise students in international law. That is a disaster. And this is really cannot be accepted. That's why I said public international law have their own class, have their own status without prejudice to the local law, because this is a special about us. That's why we are here. That's why we have a TRILA, because we have our own community that understand what we want. So I have to fight all those viruses and kick them out to ensure that the public international law in my university are being taken care for the people who understand about it for the good sake of our students. So as a conclusion, I think it's not that easy for us to build the confidence and also the goods in our student. It starts from us. We have to be very creative. We have to be very hardworking. We have to come up with all the latest issues to understand and to make sure that students were happy with us. So far, this is me and my colleague do, and also other colleagues from other universities start to, after TRILA Malaysia, start to come to me and we talk, we discuss. And I found that more important is all the developments today is more challenging, more exciting, and more enriching. So as a public international law lecturer, my passion and my soul is here. So that's why for me, all of my friends in Vietnam and all of you, I believe your passion is same with me. So don't give up. Always think the obstacle and the challenges that we face every day is a part and parcel of our duty to give the best to the students and to the university and the country. Thank you very much.
Thank you, Dr. Salawati, so much for that passionate and inspiring presentation. And this is exactly why we felt it is so important to hear from you, because your example, both in terms of your passion for the subject and also your different suggestions about how to deal with the many challenges you face. So for instance, it's interesting that, a common theme is the question about how we can persuade our colleagues who teach domestic law about the importance of international law and how we can create those foundations. So thank you very much again, Dr. Salawati. Our next speaker is another, wonderful supporter of TRILA and someone who has done a huge amount of work in his own country to inspire young international lawyers in his country, and that is Dr. Arif Saya. And Ari, we look forward to your comments on Indonesia. Thanks.
Okay, Tony, thank you so much for your kind introduction. Let me turn on my stopwatch because I'm afraid to pass the time. All right. Can you see my slide and my voice as well? Okay, good. Thank you. So thank you very much for this opportunity to share about Indonesia's condition in terms of teaching and research in international law. Again, I share many things with previous speakers, Professor Jung and Professor Salawati, especially in terms of the teaching and research in a pandemic condition. However, I would like to focus more on the condition of the staff and also about the students and also related the facility around that, because I believe that the challenges in doing teaching and also research is very much influenced by those factors as well. So if I may continue my presentation, First, I would like to highlight a general condition on law subject in Indonesian higher education. And then, for this opportunity, I have a very, privilege to have a very short survey across Indonesian law faculties in order to give a real situation. And then this surveys, I highlighted to 3 parts. First one is the students, second one is staff, and also the last one, of course, the challenges on teaching and research. So law subject in Indonesia is one of the oldest subject in higher education. We are coming second after the medical school. And it is very much the subject that everyone already knows, but unfortunately, in the early days of Indonesia, law is not becoming so popular. However, it gains its popularity after the Reformation era, after the fall of our President Suharto. And then today, as of this stage, I proudly to say that the law is one of the most popular subject in higher education right now. It shows that in every year, in the last 10 years, law subject becoming the first option for the newly graduated high school students to choose their major in the university level. And then, of course, the main professions for our graduates becoming lawyers in the corporate firms, especially in Jakarta. And then also some of them becomes public servant, like the civil servants, judges, police, and etc. However, the main profession still becoming the lawyers in corporate firms. And public international law, just that one course, is becoming one of the compulsory subject in all law faculties in Indonesia. We have this consortium of the law deans that try to keep from time to time the curriculum that applicable to all over Indonesia. So what I did for the survey, of course, if I talk by myself, I will not be representing Indonesia as a whole, but I tried to make the survey in such limited time. And I conducted 226 law faculties of state university. This is out of 70 law faculties, both state and private university. And I asked for the head departments or senior lecturers. So in terms of the students, as you can see here, the per batch of per year that our intake per law faculties is I think a big one. Yeah. Almost more than half is 500 or more. Yeah. And then compared to the students who actually specializing in international law is very much in contrast, because there's only 5 law faculties that reach 50 or more students that specialize in international law. The rest of the law faculties is between 40 or less. And then again, the most popular fields for the law students, the first one is, of course, the private or economic law, because they want to become a private corporate law firms. And then the second one comes the criminal law. Yeah. And then after that, the procedural law, but that's only one faculties. Yeah. And then the staff. Yeah. The staff, it's not so many as we think, because most of law faculties, more than half is less than 20. Yeah, so we can see that how small is the members of the staff who specializes in international law. And again, if we ask how many professors, full professors that they're in the universities, is very low. You can imagine only 2 law faculties that have more than 5 professors in international law. The rest of them is very low, especially the one has 0 professors. There are 12 law faculties. So we can imagine how hard to become a law professors in international law in Indonesia. At UI, we have only 1 active professor, that is Professor 𝐏𝐫𝐚𝐧 Juwana. And then if we ask again, how many the academic staff with doctoral degree in international law, it is also very limited. Yeah. A small number of them hold a PhD degree, and most of them are getting from in Indonesian universities, because we think that if we can get more international exposure in terms of the PhD degree, it would be a very good exposure. And for those who are graduated from the overseas universities, only a small number of the universities. And in terms of subscription to that international database, of course, we have 14 law faculties saying that we do subscribe. But then there's also a big significant law faculties. There are no subscription or not aware of the subscription. It means that what do you call it? Many lecturers or many scholars that don't use the online databases. Out of 14 law faculties that subscribe to online databases, only 2 or 3 law faculties that quite subscribe to many databases. Rest of them only 1 or 2. So it means that it's very limitation of access to this subscription. And again, I asked this as an open-ended question, and I found that we have challenge in teaching first. Yeah, for the staff, they said that many staff hold some of important management positions, both senior and junior staff. So they don't have time to do much of the teaching. Instead of that, they still have a very much teaching load. And then they said that there's a lack of support from the top management for their what do you call it, improvement of the staff. Again, English capability also one of the challenge for Indonesian. Staff-student ratio is become also the problem, because many classes that has to be taught by a small number of staff. Insufficient number of qualified staff in terms of the doctorate degree. I don't know why, because we have so many master's degree, but not very many of the PhD degrees. And we do realize that we have a lack of teaching method that stimulates students to be more critical in learning. And they think that we need to have a more teaching method improvements by workshop or in terms of capacity building. As from the students, we acknowledge that there's a low interest from the students focused on international issues as expected in the survey. And then they also have a patient from students both in Bahasa and English literatures. Of course, it relates to the English capability. Again, student ratio becomes a problem. And then the students, interestingly, still consider the law should have the characteristic as a national law, and in which where we're going to teach about international is kind of different with the national law. And in terms of the facility, of course, as I mentioned before, lack of update references, especially foreign materials, and also the limitation of online databases subscriptions. And lack of budget from the faculty to enrich and enhance the references. And we have a lack of international cooperation in general, yeah. And we need the opportunity to have an internship in international institution to give our students more and more experience. Last thing about conducting the research, we acknowledge that we have a limitation of opportunity and research funding, especially in terms of the international law issue, yeah. And then, of course, there's a less priority from the top management on research focus, mostly on local issues. International law is considered as something out of the blue. And then, of course, the limitation of access, both references, legal databases, court decision, and we do acknowledge that the ability to find the state of the art of the research is a very difficult one. A little bit more time. We also don't have the custom to study the court decision or previous decision, because we are not accustomed to it. And then we also have a lack information on issues for research, because sometimes we don't know relates to with the practitioners and also the academician. And also in terms of research, I think we need to have a more collaborative research in terms of international cooperation. And this is our internal problems, because sometimes if we submit our proposal to the university or even the government, the reviewers of those proposals is many of them are not in the background of international law, let alone the background of law itself. So very low a proposal that has been what do you call it, accepted for the funding from the interest. And last one, there's a lack interest from the students to be involved in research. I guess that's all. I'm sorry if I'm too much, because there's so many things I wish to share with you, but we can have on a discussion. Thank you very much.
Thanks so much, Ari, for that fascinating overview. And let me say that Ari was the organizer of TRILA Indonesia, and we've just released the report from TRILA Indonesia. And it was amazing that Ari managed to get TRILA Indonesia in place despite the pandemic and everything else. That was our first webinar. Also, Ari, I mean, I find what you have done, your survey, really important, because at least we can begin to identify the problems in a systematic way. And it's very much something that we hope at TRILA that we will try to facilitate, which is each country can now look at its own condition and situation and try to think about ways in which to address those issues. So thank you so much again, Ari. And our next speaker is Danny, who was also the organizer of TRILA Cambodia. And Danny is in a very interesting position. Sorry. That is simply to indicate, Ari, that you still had a bit of time, Ari. But anyway, Danny organized TRILA Cambodia, and she has a very interesting background because she's involved in government, she's involved in practice, and she's also involved in academia. And one of the major issues I think that is emerging is what is the relationship between what we teach and practitioners and government. So Danny, we look forward to your presentation. Thanks.
Okay, so first of all, good morning from Cambodia. I think it's always a privilege for me to be able to engage and then connect with our colleagues back, in international law, simply because I find this forum is one of the very important forums, as we are all, using the same language, talking about issues that is then very important for this generation as well as for the next generations. However, before I begin my presentations, let me make one disclosure. So I think when I first received an email from Professor Tony back then in the 18th of March 2021, and until 4th of April, so approximately almost 20 days, I was trying to think of the contents for today's presentation. What should I share with the participants in Vietnam, as well as sharing with others scholars from Asian countries. And then it's turned out that my brain was not really cooperating with my heart at all, simply because I was simply having a zero information in mind on what to share. And then I start reaching out to my colleagues, to my seniors, as well as to juniors that are teaching, researching, and practicing international law. It was only then that I start to formulate some ideas on what to share with everyone today. Now, you might wonder, why would I need to waste everyone's time, talking about the disclosures? The answer is quite very simple. I want to stress on the points that we are better when we are sharing, when we are communicating with each other. And that is the reason why the event that we have today is important. I believe that many of us as international law practitioners, as researchers, as teachers, we are facing the same or at least somehow similar problems in our daily life. But then the way that we approach the matters could be different. And that is the reason why I think that my points number 2 and point number 4 might be relatable to everyone, and yet slightly could be a bit different. And I hope that it will also end up to, it will be an addition to all the comment that has been made by the previous panelists as well. So for the challenges, I have divided the challenges into 3 main categories. The first challenges, I believe it's similar to others. We're talking about this limited resources in our own native language. I've heard Professor Fuchs talk a moment ago about this similar matter as well. Also, the other problem that we are facing is the selections of relevant materials. So we have abundance of material available. It could be the situation, especially if you are reading the second languages. But then at the same time, we need to think about what would be the appropriate materials to select for the students. And the second challenge is the factors that is then dealing with the educators as well as the instructor themselves. And that is also the factor that me is also contributing to it as well. So it's the issue with inadequate trainings. When we were out there teaching international law, I assume not so many of us here in Cambodia was able to receive what we call adequate training in order to become a good international law lecturers or professor. So that is one of the issues. Second thing is about the incentive, because then teachings, well, in Cambodia, if you are teachers, you might not earn enough. So that is why many of us, including myself, are multitasking. And because of this limited of incentive, it leads to the issue of time constraint that we have, simply because we need to do not only just one thing, but to do many things in order to survive. We do not have enough times to do proper research or to do additional research, to keep ourselves updated with the trends that is then happening worldwide. So those are the main challenges, and I believe it's also shared by others people in Asia when it comes to teaching international law. The last factors, and I think it's a common things now, students are demotivated. They do not find any specific incentive to study or to further their career that much in international law. So those are the challenges. Now, let's take a look at the step that has been taken. So me and my colleague, we trying to come up with some of the solutions for the challenges that we are facing. And we believe that some are actually, quite good to share to others. And these are the things that we think are the one that is then quite good thus far in terms of the solutions. So with regard to the materials, we know of our own constraints. And instead, what we're trying to do is we're trying to encourage dialogues among the relevant persons. We're trying to discuss, we're trying to agree on topics that need to be covered, or materials that need to be covered as well. So that is one of the reasons why the report of TRILA in Singapore demonstrated that many of the Cambodian professors or lecturers are using the same teachings material when it's come to international law. And that was the book on in international law in a nutshell. So that was the motivations behind this. Second, the educator and the instructor ourselves, we're trying to engage with our potential partners. So that is what me and my other college is trying to do. We participate in TRILA in Singapore back then in 2018. We also was very fortunate that Professor Tony and his team was able to bring TRILA to Cambodia, make it very special to our own editions. I believe we probably were the second country that were able to have that privilege. So we was quite probably the first. I think I thought probably Sri Lanka was the first one, and then Cambodia. So it's kind of like a privilege for us as well. And then we're trying to also find other, incentive. So when it's come to researching, we're trying to engage ourselves with the partner that we already have. We're trying to think of a research project so that, we could actually teach and at the same time do certain research and then share our research to our students. When it's come to encouraging or creating passion or interest among students, as well as letting the student knows what are the job opportunities that are available, I believe this is also linked with the way that we select the materials for the student as well. And that's bring me to my next slide, which is then this slide. So here, we're trying to engage the student with things that is then domestic to them. So when it's come to teaching international law, we're trying to make sure that the temple of Prabhupada case, which is then we are one of the parties, was then discussed in our class. We're trying to make sure that, okay, when it's come to statehood and then legitimacy of government, will be able to raise the situation of our country back then during the Khmer Rouge regimes, because we believe there was something that is then unique. That was something that then need to be heard by other countries, since it was already one of the state practices already from our side. So, and also we want to make sure that internship opportunities at the extraordinary chamber in the court of Cambodia is available to our student, that the student knows that if they study international law, there is a career opportunity available for them right at our homes, and they do not need to, go anywhere else in order to seek for the job availability if they just want to practice in their own country. And then we want to make sure that prominent cases will be raised in our class. We want to make sure that the question, international law question that is then happening right next to our door, for example, the South China Sea arbitrations, the questions concerning relating to the detention of certain document and data that was then between Timor-Leste and Australia was then raised in our class. We want to make sure that the North Sea continental shelf was always there for the student. And then the military and paramilitary activities in and again Nicaragua was also part of the discussion to a certain extent. So that it was something that is going to be trying to do so that it would actually encourage our students when it's come to their passions. Now, this is the additional challenges that we face during the pandemics. I know that I have less than 2 minutes. So 2 points to make. One is on the logistic matters. I believe it's the same to everyone. We have issue, we have students coming from different backgrounds. So one thing that we need to guarantee is to make sure that regardless of their backgrounds, their ability to join online platforms, to join online classes is possible. So we try to find a ways to deal with those challenges. We know that teaching and learning environment at home is different from teaching and learning environments in classroom. So we talk and discuss and find ways to deal with that matters. My last point, when it's in the last minute, is the way forwards. Now, so how do I view international law forwards for Cambodia as well as for ASEAN? I think one of the important things is to learn to accept and realize that, yes, there are challenges, but do not see it as a problem. Do not see it as an obstacle. Do not see it as an obstruction to our futures. We should view it as an opportunity to make things better for us and for the next generation as well. Second point is something to deal with the basic materials and the compendiums. I start to think that if we could have a basic material and a great compendiums that is specifically designed for Cambodia or specifically designed for ASEAN's professor or lecturer who are teaching international law, that would be something that is then added to the solution that we could come up with. And the last point is, it's important to always have in mind that we want to project the ASEAN perspective in international law, simply because ASEAN perspective, it's always different from the Western perspective. It's different from the way Africans perspective, African state view the matter on international law as well. And then also ends my presentation. And thank you once again for this wonderful opportunity.
Thanks so much again, Danny. And let me say that TRILA Cambodia was our first TRILA overseas. It happened before TRILA Sri Lanka. So you've been the pioneer. And you've raised very interesting and important questions, for example, about materials that are being used and so forth. And we'll talk more about that. But at TRILA, we are very conscious about trying to establish a collection of Asian materials, so that Asian countries can draw upon that database to get Asian materials to teach their students to help make international law more accessible and more relevant. So thanks again, Danny. And our next speaker is Dr. Usani from beautiful Chiang Mai in Thailand. I haven't been to Chiang Mai. I'm looking forward to going there because I know that there are many wonderful golf courses in Chiang Mai. Thanks so much, Dr. Usani, for joining us, and we look forward to hearing from you about the situation in Thailand.
Okay. Good morning, everyone. I am 𝐏𝐫𝐚𝐧 from Faculty of Law, Chiang Mai University. First of all, I would like to thank you, the organizer, for inviting me to join this panel. And I have learned so much from the previous panelists with a lot of passion and experience that we can share. And I want to say hello to all the participants in Vietnam also. I have a very good memories from my previous visits, and usually I receive a very warm welcome from friends from Ho Chi Minh University and Hanoi Law University. And special thanks to Dean Tran Viet Dung also for inviting me. Okay, I would like to talk a little bit about the challenge of teaching international law in Thailand. And I agree with all the panelists for all the challenge we face. And I would like to add a little bit about the Thailand perspective. First, the international law in LLB curriculum. In Thailand, bachelor degree in law usually take 4 years, and the minimum requirement is 120 credits, which equivalent to about 40 subjects. And we have public international law as a mandatory course taught in 2nd or 3rd years, but we only have 1 semester. So 45 hours to talk about all the material and everything in international law. And then faculty offer elective course related to international law, for example, law on treaty, law of the sea, international organization, international trade law, human rights, criminal law, and everything. And we insist on regional integration, especially ASEAN, in many universities. This I want to talk a little bit because I think it has a lot of influence in the perception of the place of international law in Thailand for students and also for law practitioners. This is the career pathway for lawyers in Thailand. After graduation with the LLB, many students will have to take many exams before they can practice. And the first one is a lawyer council exam in order to get the lawyer license. And the most important one is the Thai bar exam, because this is required if you want to become judge public prosecutor in Thailand. So they take Thai bar exam, and it's a very difficult one with 4 main subjects. And then with the experience in legal profession and cases, they can pass the test. But the test to become judge and public prosecutor in Thailand with the normal track is very competitive. Less than 1% passed the exam. For example, in 2017, 7,000 took the test and only 40% passed the test. So it's more like the dream career of a lawyer in Thailand. And another option is after LLB, you can further your study, and to become a law lecturer, PhD is required. For me, challenge in teaching international in law in Thailand, I group it in 3 main ideas. I think the most important challenge is to make the student realize that international law matters. And I think this is the most important one. And then the challenge is related to specificity of international law, which is different from domestic law that students are familiar. And the last one is the lack of foreign language skill, which is an important instrument or tool to access knowledge in international law. For student perception that international law doesn't matter that much or is not that related to their legal career, I think is linked to 2 main points. The first one, because Thailand is a dualist tradition. So the treaties will be transposed into Thai law, into act or lawyer decree first. And so as a lawyer or practitioner in Thailand, you apply the law as an internal law, as a domestic law. So international is less visible. We don't talk much about international custom. So mainly treaty already transformed into Thai law. So all I need to do is to apply Thai law. And the second one is as I explained before, after LLB, the students still have to take many tests in order to be able to practice. And all these tests, international law isn't given that much important place. For example, in Thai bar exam, there are emphasis is given to civil, criminal, civil procedure, civil criminal procedure. And that's one question about international trade law. And the same for judge or public prosecutor exam. So the student can succeed very well without knowing international law. As for specificity of international law, as Professor Slavati mentioned, we need to make the student understand that we are in different concept, different nature, and it's not exactly the same as a domestic law. And so once we get through this, the student may say, why not binding? Why you don't need to go to court? And so many questions arising at first. And the last one is the foreign language and especially English skill. Students are not that comfortable when they have to face with a lot of English material. They get discouraged already. And so there's material in Thai, but not everything is translated. And anyway, you need English in order to access knowledge, case law and everything in international law. So I think Thailand has realized this, and we start to request English in the bar exam, but it has just started. So for I think two times. About research, I think there's a question of funding because the limited funding, like Professor Ari has mentioned also, and sometimes the topic request or offer is not necessarily related to international law. And the last one is more in general, because with being lecturer in university, nowadays we are requested to do many things like teaching load and also administration and also student development. So we need to very manage the time in order to be more focused in research. Last but not least, about the challenge in teaching during COVID, I think the most important is to engage the student, because in class we can make sure they understand by looking into the eyes, but through virtual communication sometimes is more difficult, and some students have limited access to internet and equipment, and we all have to adapt with new style of teaching, evaluation, and so it's a challenge for us. But I think everyone try their best to really continue giving good quality lecture and to be there for the student through the communication. Okay, so thank you very much for your attention. And here is my email if there's anything I can be of.
So thanks so much, Dr. Usani, for that very interesting and in-depth presentation, and demonstrating the importance of the incentives and the bar exams and so forth. But it's also interesting, isn't it? I think in Thailand, there's a special code for intellectual property that was established. And what that seems to suggest is that, it's very important to understand TRIPS, the global international intellectual property regime. And so even judges in the Thai system, and it's a very competitive exam, I understand, but even judges who get into the system then would have to learn international law in order to function properly, for example, in those special courts. But I think there's a general comment I might just make at this stage, which is, I think as teachers, we should say that international law is important not just for people who practice international law. So I think many of the comments that people made, like Ari, Dr. Salavati, my suggestion would be that all government officials, even if they're working on something like nuclear energy, they would benefit from knowing something about international law. So international law connects with everything. And it's not just for the purpose of following a career in international law that you should study international law. You should study international law because it would be a very important part of almost any major government. If you're going to be a senior government official, at some stage or another, you're going to encounter international law issues, whether you're dealing with intellectual property, medicines, for example, think of the pandemic. Just an anecdote, what I found interesting, there's a program in Australia, the master's program that is offered in many Australian universities. And what I found interesting is that many of the people doing that program are government officials who have had a very successful career, but then find that in order to take the next step, they need to have some understanding of international law. In other words, the further people develop and progress in their careers, the more they discover that they might need international law. So I think that's perhaps important in terms of how we present the importance of international law, not just to follow a career specifically in international law. Okay, those are just some general comments, but thank you so much to everybody for the rich presentations and also for keeping to time. That is extremely helpful. We started late, so I think we'll have about 10 minutes for questions or comments. I have got many questions and comments, but let's open it to participants who have been very patiently waiting throughout this. So could I ask people to indicate, you can, on the chat function, for example, you can include your questions or comments. But otherwise, I'm sure we're happy to continue our discussion among ourselves. But one of the important things about TRILA is we want to hear from the participants. It is a bottom-up process. So let me just open this up for discussion and from our participants from Vietnam and elsewhere. Or otherwise, we can continue our discussion among ourselves, waiting for people to ask questions in that regard. So many issues to raise. So the panel will continue our discussions among ourselves until people present questions, and we will have up to 9:50 Vietnam time, which is 10 minutes, in order to do that. So let me just ask a general question. It's a very common issue, this problem of language. And I'm just interested to hear, now, Dr. Usani, you mentioned that there's an emphasis now on teaching English, that has become a part of the system. So I'm just wondering what others think about that approach. Should English be compulsory? Should the university itself offer a course in English to law students? So in Sri Lanka, for example, there's one university which says, we want people to, they offer training in English together with the law course because it's understood that English is important. Would that be one approach to take? So I'm open to suggestions, comments about the language issue. Zung, you're going to say something?
Yes, yeah. I think that is an excellent idea, and actually we are trying we are planning to do this in maybe next semester. And we are designing a program which will be conducted entirely in English, and which will be launched maybe next semester. Yeah, and the requirement, of course, but the still again the challenge for the students participating in this program that they must have adequate English ability to take part in this course. So I think yeah, we I don't know what is the result, but we hope that that can be an important way to to overcome the issues of shortage of materials, teaching materials, and also the limitation for the for the student to have the lecture with the foreign professors. I think if we can overcome that, I think that we can integrate better. And I think it's also another factor that our university is considering is that about the program. So with this international fully conducted in English, we can exchange the students, international students, which and again will influence for the Vietnamese students to study the law and international law. Most of the subjects that.
Sorry, Zung, you're breaking up.
I think the connection is not good.
Yeah, sorry, Zung, we'll come back to you. Okay, so we'll come back to you. But Dr. Phuc has some comments. Dr. Phuc, you're going to add to that.
All right. So Tony, to respond to your question concerning the teaching English, right, for law students. So actually, I think in Vietnam and other ASEAN countries, we have at the moment we have a huge debate about this issue. Should we, because English is now trendy, not only in law, education, but in any field. Like in Vietnam, we see they try to establish in business, even in technician. Course they try to offer program. We try to offer program 100% in English, so it's trendy, and the student when they apply, they're happy with that. However, in law, we have huge debate. Some universities think that we should teach 100% of the courses in English. However, from our perspective in our university, so look at the issues we're considering. So since the court, so since the government, they still use Vietnamese. So as their official language, right? So then if the student graduate from that program, so how can they work in the law firm and apply the knowledge? Another issue is that since the Vietnamese law, right, established in Vietnamese, so when we translate Vietnamese law into English and teach Vietnamese, so we're in a huge trouble. So our approach at the moment is that, so if the course is international, like international trade law, international law, something like that, international business law. So we try to deliver in English for the student in some special program. But then again, another issue is about the human resources. So we don't have much lecturer at the moment can deliver fully in English for those courses. And then another issues come with the material. And yeah, so it's a big question we think of. So however, in Vietnam now we have the Vietnam Law School networks. We have around 60 members. So we try to solve the problem of the human resources. We sign MOU to each other, and we try to provide the lecturer. So if you need it, another issues happen. So for the courses like international law, international trade law. So each university we already have expert like Professor 𝐏𝐸𝐿 and now the lecturer in Vietnam. So that's been a huge problem now, and I don't know. So I want to hear from you. So how would other countries solve these issues?
Sure, you're quite right. It's a big issue. I mean, ideally, people will be bilingual. In other words, they would be completely expert in Vietnamese, but also familiar with English. But it's easier to say that than to do that. I think Danny, you had a question, and then we have a question in the chat, which we will come to.
So I raise hand simply because I have some of the experiences that I think might be helpful to our colleague in Vietnam and probably to other countries, and also in responding to your question as well. So when it's come to the question, two things that struck into my mind. One, are we talking about, you know, an additional English course incorporating into our existing law curriculum in our own language? Or two, to have a program that is then completely in English language, just like the one that I used to work for before. So for example, the situations in Cambodia is that we have an English course available for the student, and that is an addition to the Khmer law curriculum that they are taking. So, and I saw that is also helpful because at least it's introduced students to some of the legal terms that is then quite important for their legal career in the future, regardless of whether they are wanting to practice in private or public law. The program that I used to work for is designed specifically, the courses is conducted in English, and it's not the only program now, simply because we have other programs, we have other schools trying to create similar program as well. I would say is that in terms of the capacity and ability of the student, thus far from my experience, that students from the English touch programs tend to do better. there was concerns that before, and I believe that was the concern that is raised by our colleagues from Vietnam, is that what are we going to do, simply because, you know, if you're working, if you want to work for government, or if you want to work for and got admitted into the bar practice in Cambodia, you want to get admitted to become the judge, then you don't really need to use English language or any other language. But then that was not an issue, simply because I mean, we were able to receive support from Ministry of Education. So regardless of whether the student is taught in English course, in English language, but then the course that we design is minimum. I mean, we're trying to do the balance. We're trying to incorporate some of those basic courses that is then required for their admission to the law, to being a lawyer or being a judge. And we also trying to incorporate more of in international courses into them. So instead of having the curriculum, the number of credit to, you know, the minimum one that the ministry require us to have, we tend to add additional credits to our program. So that was something that we have done, and it's turned out to be quite successful as well, because then the number of students who are enrolling is increasing.
Great. Thanks so much, Danny. And it seems that the one thing in common is that regardless of whether students want to become international lawyers or not, English is popular because it's understood as being important for career progress, even if you're going to be in a private law firm or in government. So I think we'll take one more question since we're running out of time. And this is from 𝐷𝐿 Nguyen at the University of Brighton, who has been pointing to the issue of limitation of access to foreign materials because of the cost, and also restrictions on language capacity. So we've talked a bit about language capacity. So this question about foreign materials, and it's a problem that I think all our speakers have pointed to, the lack of resources to support study of in international law. And it seems that we're all suffering, especially after the pandemic, from a lack of resources. But at least, hopefully, the government officials understand the importance of the resources. So even if they're currently lacking the resources, they understand the importance of resources and try to do something about that. I sometimes tell my students in the United States that I feel that they have more resources as students in the United States than the foreign ministry in Sri Lanka, because students in the United States have access to LexisNexis, Westlaw, all the databases, and the foreign ministry in Sri Lanka itself is struggling to get access to those materials. There's a real imbalance. So it's a very good question from 𝐷𝐿 Nguyen. Should we increase the fees from the students, or should we accept, or should we look for government funding? Or the third possibility is to try and work out ways of collaborating among ourselves for those of us who have resources to actually share those resources with others. So just a final thought, I just to close the panel, Ari, your quick thoughts, Dr. Salawati, your quick thoughts.
Yeah, as for us in Indonesia, English language is still a second language for us. However, considering the most recent generation right now, what we call it Z generation, I guess more and more younger people speak English more fluently, and I believe this is going a good trend. But however, in terms of attracting them to learn international law is another challenge for us. Thank you.
Thanks, Ari. Dr. Salawati?
For us in Malaysia, undergraduate, the third year, we teach them in English. We don't teach in master because it's very hard. For all the master's program, all in English, and we don't have any problem so far because we have English proficiency test before they can come to our international law program.
Great. Dr. Usani, final thoughts about resources or language?
I think in Thailand, we are still quite lucky. University have some support for the resource, but it's also a question we ask ourselves. For example, is it worth it to have Westlaw, which costs a lot and high online, when only 5 lecturers do research in English? So
Right.
this is, we also think about the community, what is the most important to use the money for. But I think it's essential to have it, even it costs a lot, but maybe we can think of a way to share between university or something in the province in order to allow access to electronic database. Right.
Great. Well, thank you so much to everybody again for an extremely stimulating, wide-ranging, and informative panel.
Thank you.